Welcome to Legal Scrubs, a podcast focused on the business side of healthcare for health professionals who want to start, grow, and protect their practices the right way. I'm your host, Attorney Dan Smith, the founder and owner of DPS Legal Counsel. So without further delay, let's get started. Here's today's episode of Legal Scrubs. Hi, today's podcast episode is about restrictive covenants for physician practices in Tennessee. And first of all, let's start with this. If you are a physician who's entering into a contract in Tennessee, perhaps as a new employed physician, maybe you've just gotten out of your residency and you're presented with a contract that has a restrictive covenant in it, a non-compete provision in it, you really want to take a look at that provision very carefully, because when you sign that agreement and you're binding yourself to abide by this non-compete, it's a very serious thing, because if it doesn't work out at your practice and you want to leave, and perhaps you've bought a house or you've gotten involved in the community and you want to stay there and practice medicine after you leave the practice that you've signed on with, that restrictive covenant, that covenant not to compete, could be a real roadblock for you in staying there and working. Because in Tennessee, generally, by statute, restrictive covenants affecting physicians are enforceable generally, as long as the scope of the restrictive covenant falls within the limits of the statute. And the limits in the statute are these. It can be no longer than, have a duration of no more than 2 years, and the geographic area that it covers is generally limited to the greater of 10 miles from the primary practice site or the county in which the primary practice site is located, whichever is greater. There is one slight wrinkle that the restrictive covenant can have no geographic area stated, but may restrict the physician from practicing at any facility that at which the practice does its work, its practice during the time that the physician is employed. So you might have a restrictive covenant that instead of saying you can't practice in this county for 2 years, or you can't practice within 10 miles of the practice site for 2 years, it might say you can't practice at X, Y, and Z hospital or X, Y, and Z surgery facilities for 2 years, if those are sites or facilities that the practice has provided services at during the time that you were there as an employed physician. So, going back to what I said, if you're getting ready to enter into an employment agreement with a group practice, please take the time to review it carefully, and don't sign on the dotted line if you have any questions about some of its provisions, particularly if it has a restrictive covenant, because that could have a really detrimental effect on you going forward. Now, some of the things you might want to consider doing when you're negotiating your employment agreement, besides getting an attorney to advise you and to help you with those negotiations and the review of your agreement, are to perhaps ask the practice to eliminate the restrictive covenant. Now, they may not be willing to do that entirely, but they might be willing to limit it more than it's presented to you at first blush, maybe 1 year or 6 months, or maybe limit the scope a little bit so that you could continue to live in the area and practice in the area in a way that wouldn't harm the practice if you leave, but would also give you the benefit of being able to stay. You might want to have a provision that says if you stay for a certain number of years working with the practice, that the covenant not to compete goes away, because you wouldn't want, for example, to be at a practice for a long time, really have put down roots in the area and still have this non-compete. It might be the case that if you've served a good number of years at a practice, that maybe that non-compete should go away. Now, other situations where the non-compete can come up is if you are buying into a practice, or let's say you are signing on as an employed physician, but part of what you're doing when you're signing up is getting the right to buy into the practice after 2, 3, 4, or 5 years. And it may be that the buy-in would involve you signing the operating agreement among all the physicians, and one of the provisions might be a restrictive covenant. Now again, you want to take care and not sign on and agree to a restrictive covenant that's going to adversely affect your lifestyle and your ability to practice your profession, practice medicine in the area that you want to live. You may have to make a decision about signing a contract or going to work for a particular practice if the non-compete seems to be too overly restrictive to you. You shouldn't expect to just sign on the dotted line and without questioning some provisions in a contract. You have the right, you have the best leverage you're ever going to have when you are signing on to a practice to make whatever changes you want to make or suggest some revisions at that time than you're ever going to have. So don't be shy or timid about asking questions or even trying to negotiate changes to your agreement when you're signing on as a new physician at a practice. I hope this helps, and thanks for watching today's episode of Legal Scrubs.
That about wraps it up for today's episode of Legal Scrubs. Thank you again for listening. You can find my contact information at the website of dpslegalcounsel.com. And if you enjoyed or learned something of value to your practice, I would appreciate your leaving a review. And if you would like to make sure you don't miss any future episodes of Legal Scrubs, then hit the subscribe button where you get your favorite podcasts. Thanks again. We'll see you next time on Legal Scrubs.